Ever wondered what happens when legal agreements get a little, well, blurry?
Mm-hmm.
Especially with something as common as buying or selling a vehicle.
Mm-hmm.
We're diving into a fascinating Supreme Court of India case you asked about, Brij Bihari Gupta versus Manmet Ors. It really highlights those tricky gray areas.
That's right. It's a civil appeal stemming from a motor vehicle accident. And the big question wasn't if someone should pay compensation, but who?
Who's on the hook?
Exactly. The insurance company pushed back against the initial awards, trying to avoid paying out.
So our mission today, unpack the two main arguments the insurer used, and crucially, look at the surprising facts the Supreme Court found that really changed everything. It's about details many of us might miss.
Absolutely. Details matter.
Okay, let's get into it. The insurance company had two main reasons they argued they weren't liable. First, they said the injured people were gratuitous passengers,
Right.
meaning people just riding along for free in a goods vehicle, not really connected to the cargo. Seems like a solid argument for the insurer, maybe.
You'd think so initially, but what's fascinating is how the court really looked at the context.
Right.
These weren't just random people. The injured and sadly the deceased were petty hawkers, a fishmonger, a vegetable hawker.
Ah.
And the evidence showed they were actually traveling with their own goods, their baskets of fish, their vegetables.
So they were accompanying their cargo.
Precisely. And get this, the insurer's own witness admitted they had no real knowledge about whether these people were gratuitous or not.
Oh, interesting.
So the court found, under Section 147 of the Motor Vehicle Act, which defines mandatory insurance cover, that if you're accompanying your own goods for their safety in a goods vehicle, you're not a gratuitous passenger.
Okay, so that argument didn't fly. The court saw the practical reality. They were there for their goods, basically for work.
Exactly. It wasn't a free ride. It was tied to their livelihood. It's a really important distinction, purpose matters.
Right. It's not just who is in the vehicle, but why.
Yeah.
Huge point for anyone using or insuring these types of vehicles. All right, so argument one fails. What was the second angle the insurance company took? This one gets really interesting, I think.
It does. They claimed the driver was the ostensible owner.
A sensible owner, meaning he looked like the owner.
Kind of. They argue he was the real owner in practice, even though the truck was officially registered to someone else. And the insurance policy. It was in the registered owner's name.
So they're trying to shift blame from the person they actually insured. How did that work?
Well, they pointed to an agreement between the registered owner and the driver, who was the appellant here.
An agreement to sell the vehicle.
Yes. The price was set at 90,000 rupees, but, and this is the key part, only 80,000 had actually been paid.
Ah, so 10,000 was still outstanding.
Correct. And crucially, the agreement stated that the official transfer of registration was conditional on that full payment being made.
Okay, so the condition wasn't met.
Right. And even later, when the vehicle was released from a magistrate's court after the accident, the registration record still showed the original owner's name. It hadn't been updated.
Wow. So even with a sale agreement, maybe even a handshake, if that final payment isn't made and the official registration isn't transferred, the original registered owner is still legally the owner.
That's exactly what the court found. They leaned heavily on Section 50 of the Motor Vehicle Act.
Which says?
Basically, that legal ownership for the purposes of the act stays with the person whose name is on the registration certificate until the transfer is formally reported and recorded by the registering authority.
So the paperwork is everything.
It really is in this legal context. The Supreme Court cited other cases too, like Naveen Kumar versus Vijay Kumar, reinforcing this principle. The liability to compensate victims falls squarely on the registered owner.
Why is that so strict?
It's vital to protect claimants. Imagine having to track down who really owns a vehicle based on private agreements. It would be a nightmare. The registration provides clarity.
Makes sense. So because the registered owner was still legally the owner?
The insurance company, having insured that registered owner, had to cover the liability. They had to indemnify their insured.
Even though some of these claims were settled separately.
Yes, some related appeals were settled through Lok Adalat, which is sort of an alternative dispute resolution forum in India. But for the remaining claims in this specific appeal, the insurer was held responsible for paying the compensation awards, plus interest.
So this whole deep dive really hammers home one point. When it comes to vehicle liability, that official paperwork, the registration, is paramount in the eyes of the law.
Absolutely. The court didn't just look at appearances, it looked at the documented legal facts. It ensured the victims were protected.
It's a critical lesson about following through on those official transfer steps.
And it leaves us with a thought, doesn't it, for you listening? If you're ever buying, selling, or even just lending a vehicle, think about what steps you need to take up front to make sure all those legal liabilities are absolutely clear, long before anything unfortunate might happen.